All right, welcome to this presentation of unemployment benefit eligibility in Nevada. My name is Ray Gertkin, and I'm the directing attorney of the Reno office of Nevada Legal Services. I am joined by David Olshan with our Las Vegas office. Hello, David.
Sorry, I didn't mean to step on your toes. This is David, yay!
All right, but we will go ahead and get started with the presentation on unemployment benefits. So just as a disclaimer, just remember that the information contained in the presentation is provided for educational and informational purposes only and should not be construed as legal advice or as an offer to perform legal services on any subject matter. All right, but as far as an outline for this presentation, we will be going over eligibility for unemployment benefits, grounds for disqualification of benefits, the claims process, and briefly touch on hearings and appeals. And all of the resources will be linked in the description box below. I don't think I got them there. I apologize before we started, but I will have them linked after the presentation. All right, so first we're going to talk about eligibility for benefits. So the first thing is, who is unemployed? So a person is unemployed for any week during which that person performs no services and receives no pay. So we get a lot of questions from people. Well, my employer says I'm still employed with them, but I haven't been on the schedule in 2 weeks and I haven't received a paycheck. You are unemployed. Your employer cannot frustrate the unemployment benefit system just by saying that you're still employed, but not scheduling you and not paying you for work. Okay. But that also means then you can be eligible for partial unemployment. So if you're working less than full time, say your employer had to shut down, but is letting everybody work, but it's for severely reduced circumstances, we're going to talk about good cause to quit, but you can also be eligible for partial unemployment benefits. So if you're working less than full time and the wages are less than the person's weekly benefit amount, you can apply for unemployment benefits and potentially be eligible to receive the benefits plus the $600 in the PUC. But one thing to remember, and I will address this again, you are not unemployed if you're paid disability or rehab payments, you receive a vacation payout, you're being paid sick leave or any other type of leave benefit, or you receive a severance package. And so if your employer is paying you out vacation or sick leave or other paid leave, you are not considered unemployed, and your employer can choose to do this. You can't refuse to accept the money, essentially, if your employer is paying you the benefits. And then generally, under normal circumstances, you're not eligible for benefits if you're self-employed or otherwise not an employee. For example, you work as an independent contractor, you receive a 1099. But you are now eligible for pandemic unemployment assistance. As we learned last week, pandemic unemployment assistance is now available at employeenv.gov. And we're going to call it PUA, but PUA is a new unemployment benefit program to cover individuals that have not traditionally been eligible for unemployment benefits, but can now potentially receive benefits due to the economic toll of COVID-19. So who is now eligible for PUA? You're eligible if you're unemployed or partially unemployed as a self-employed worker, a 1099 contract or gig worker, an employee whose wages were not reported for unemployment benefit purposes, such as religious workers were generally not or traditionally considered covered employment, employees who have not earned enough to be covered, or individuals who are unable to start a job because of COVID-19. So all of these individuals will not normally be eligible for state unemployment benefits under the regular unemployment benefit process, but are now eligible for this additional benefit called pandemic unemployment assistance.
One of the things I should mention is that when people first apply, they're going to get an earnings history. They're going to get information supplied by their employer. So if any of this earnings information is wrong, you should correct it. Sometimes it might help you if it's inaccurate, but you shouldn't maintain that inaccuracy, because like with PUA, it's much better if you don't have an earnings history than getting like regular unemployment that's not enough to help you at this point. So
Right. So as we learned last week, at the employeenv.gov site, it is a completely separate system than the uinv.gov site that you would apply for normal benefits. Now, when you apply for state unemployment benefits, what a lot of people, I believe, have been getting back is a monetary determination that lists your work history as 0. Now, if that's wrong, if you worked, say, for a casino or something, obviously you want to challenge that with the unemployment office. But if you were a gig worker, 1099 or self-employed, that's actually correct because you didn't work under what's called covered employment. And so your employer, who may have been yourself essentially, didn't report to the unemployment system. And that's when the PUA process comes in. And I think we hit on this a little bit, but I'll just address it now just in case. Essentially, you have to have proof of your earnings though still. So yes, if you get a monetary determination and you believe you're eligible for traditional unemployment benefits, you have the opportunity to appeal that monetary determination to correct any errors in your wage history. If though you were a gig worker and you received that 0 monetary determination, that means that you should just go ahead and apply for PUA now at the employeenv.gov site. But have your 2019 tax return ready, because that your net income from your 2019 taxes is what is going to qualify you for benefits.
and
But we'll get into that in a second.
just a side note, this PUA and regular unemployment should be seamless. There shouldn't be 2 online systems. So the big question is, if ESD is so busy, why do they ask people to clog their system twice with 2 separate applications?
But that's an unanswerable question.
Right.
Essentially, there are 2 systems. I understand that people were able to apply over the weekend. I understand that the whole system didn't crash, but I believe it took a couple of tries. Essentially, some people got kicked out and logged off. But I understand that people have been successful in applying online at the employeenv.gov site. So it is working, but it is 2 separate systems. All right. Also, though, like regular unemployment benefits, employers who apply under the PUA system still must self-certify that you are able and available to work. Okay. So when you apply either for regular unemployment benefits or for PUA, you have to certify that you are able and available to work. Generally, able means that you're physically and mentally able to accept employment at the time you file your claim for benefits. This means that an illness or physical condition will disqualify you for benefits as long as you have the illness, and you'll need medical certification that you can return to work. Available means that you cannot have factors that would prevent you from actively seeking and accepting a full-time job. In traditional unemployment benefits, you have to have childcare. You have to have adequate transportation. You can't be in school and are unwilling to change a school schedule to accommodate work. Basically, generally anything that prevents you from accepting suitable work and the work days and hours required for the job. Unless you are unable or unavailable to work due to specific COVID-19 reasons. Essentially, the PUA creates a new eligibility group and essentially deems individuals unemployed who are unable to work or unavailable for work due to COVID-19. Remember, you cannot apply for unemployment benefits if you are receiving sick leave or other leave or paid benefits, including where your employer chooses to pay out vacation or other leave benefits. So if you're receiving some sort of sick leave due to coronavirus or the FFCRA benefits, you are not unemployed even under PUA. But these are the specific factors that go into whether or not you are unable or unavailable to work due to specific COVID-19 reasons. And these are from everything we've understood, these are going to be strictly applied. So you have to have been diagnosed with COVID-19. You have to have been quarantined or told to quarantine because of COVID-19. You are providing care for someone diagnosed with COVID-19. You are providing care for a child or other household member who can't attend school or work because it is closed due to COVID-19. Okay, these are specific factors that will be strictly applied as they're laid out. Now, the one thing that we're going to talk about also later is good cause to quit. Good cause to quit is a reason for disqualification from unemployment benefits. In this list is a factor that you had to quit your job as a direct result of COVID-19. The Department of Labor has come out and basically said a direct result of COVID-19 is if you were sick with COVID-19 and due to that illness developed other physical, mental, or illness conditions that make it so that you are unable or unavailable to go back to work. This is not going to allow you to quit just for fear of contracting COVID-19 based on the guidance that we've received from the Department of Labor and from the state unemployment office.
Well, I mean, in their press release, the Employment Security Division basically eviscerated that category and said you have to have had COVID-19. So,
Well, that's what the Department of Labor regulations essentially said, is that you had COVID-19 but developed other health factors as a direct result of that illness. So we'll talk more about what good cause to quit is, but this specific provision does not allow you to quit just because a direct result of COVID-19 is a direct result of having and contracting the illness. David, did you want to add anything else?
no, look, what it signifies overall is that they're not taking into consideration the protection of the worker, the protection of the worker's family. There's a lot of situations, there's broad leeway here. So if you're working, let's say at a restaurant that doesn't allow for social distancing, doesn't have face masks for you as an employee, that's not going to be included in this situation. But we're going to talk more about it.
Right. Right. We'll go on and we'll get to that, have another conversation about that.
Right.
So one of the things that comes with being available to work is that you must generally be actively engaged in efforts to seek and secure employment in your customary occupation. So you have to look for jobs. You have to continue to look for jobs. We look at, at least 3 jobs a week. I think 5 would be ideal. But basically that you are applying in the customary manner applications are taken for employment in your customary occupation. You have to keep written records of all of your efforts to seek work. These are called work search records. When you apply for unemployment benefits, normally the ESD would ask you to provide them written work search records. But with COVID-19, that requirement is currently suspended. So you do still have to certify that you are able and available to work unless you have one of the factors that we talked about in the last slide. But you don't actually have to provide any work search records. Now, as the economy continues to open, this is going to change. Right now, the work search requirement has been suspended, but in the future, it is likely it's not going to last much longer. So everybody should be, as the economy opens, starting to look for work again. And additionally, with extended benefits comes heightened work search requirements. So even if work searches are not required under traditional or current circumstances, once the extended benefits kick in, that is going to probably require work search records.
It's just important to keep in mind that, yes, you want to get unemployment benefits, but unemployment benefits are really insurance while you're unemployed. So the whole idea, without being too, paternalistic, is that you're just getting these benefits temporarily. Typically, what is it, 26 weeks, you're going to get them. You'll get 13 extra weeks, plus you may get some extra time under the CARES Act. But the point is, there should be some idea of going back to work, because unemployment benefits, even though there's an extra $600 now, it's not going to last forever. And the benefits are usually about half of what your normal pay is.
Correct.
And by the way, I'm not getting any comments. So if you're watching or making a comment or asking a question, I hope we can answer it at some point.
Yeah, just if you have anything, please put it in the live chat and we will try to answer as we go, or at the very least at the end of the presentation. So feel free to chat and we will address issues that come up. But essentially, workers who are not eligible for pandemic unemployment assistance include those who are, if you're eligible for regular state unemployment benefits, you are not going to be eligible for PUA. So apply for regular benefits first if there's a question, and then you can apply for PUA. Unfortunately, as David indicated, there are two separate systems. You would have to apply twice. If you do apply for PUA and you're eligible for unemployment benefits under the regular program, I believe that they will direct you to apply for regular benefits first. Workers are not eligible if you can telework with full pay or, again, receive paid sick days or paid leave. But if you can work part-time and telework, again, you could be eligible for partial unemployment benefits. So keep in mind, if you're making less than you traditionally make, you can still apply for benefits and see if you qualify. Because again, even if you qualify for $16 a week, you still get that $600 extra until the end of July. Unfortunately, workers must be authorized to work to be eligible for PUA, so undocumented workers do not qualify. So the amount of PUA, if you're eligible, you'll receive 39 weeks. And the program does expire on December 31st, but it is applicable. You can backdate allegedly as of January 27th, but at least as of March 15th. And PUA benefits are calculated the same way as they are for the Federal Disaster Unemployment Assistance Program, which requires basically a tax return. Your income is calculated based on the net income reported on your 2019 tax return. There's a minimum benefit amount that's equal to 1/2 the average weekly unemployment benefits, which is a ballpark about $190 per week. If you don't have proof of wages, then you'll get the minimum benefit amount, but you can ask for redetermination to substantiate earnings, or like if you file taxes now, essentially, because the deadline was extended to July. I would not wait. If you're going to apply for PUA, get your taxes in. But you are eligible then for the additional $600 a week.
And I just want to make a point here that let's say you go back to work, you're working now, you're not unemployed. If you were let go, if you were laid off on March 15th and just went back to work, you still would be eligible for PUA and you'd get a lump sum. So people who are back to work should also apply.
Yes, because the governor explicitly said that you can backdate your application. So do apply even if you've returned to work to get that benefit for that time period where you were unemployed.
Even if you don't want the money, donate it to charity because this is ESD's fault. They were way too slow and you should get that money that you're entitled to.
We do have a question. Can you use bank statements to show cash deposits for cash work? I don't know the answer to that question. I would say it would be better if you had a tax form. So a W-2, a 1099. Obviously, you're probably not going to have a W-2 unless you didn't work enough.
My guess would be, yeah, they're going to look at the tax form before the bank deposits. Because
Right.
the tax form, there's a penalty of perjury, whereas bank deposits.
Yeah, and if you have a cash deposit, how are you going to substantiate that that's from employment? You're
Right.
going to need more than that potentially, and you really do need to file taxes. I mean, the tax return is specifically required. Now, would they let you substantiate with other forms? If it's like a 1099, I mean, maybe, but it really does require a tax return to get more than the weekly benefit amount, the minimum benefit amount. I do not think bank statements are going to be enough, especially if it's just cash deposits.
Right. I would agree with that.
Okay. Under normal regular state unemployment benefits, the weekly benefit amount is based on your income. So there's a calculation, it's 1/125th of your total wages, but no less than $16 per week. And then the maximum weekly benefit amount is $469 a week. If you work while you're getting benefits, again, that's fine. You can get partial unemployment benefits, but your weekly benefit amount will be reduced based on the amount that you're getting. Again, you're also eligible for PUC, which is the extra $600 a week, and that does end July 31st. And then that PUC is not income for purposes of eligibility for either Medicaid or CHIP and some subsidized housing. All right. Now we're going to move on to the basis for disqualification for unemployment benefits after you've applied for benefits. Generally, as we've said, unemployment benefits are available to unemployed workers who are out of work due to no fault of their own. This means that otherwise eligible unemployed workers may be found ineligible for other reasons. As we discussed, the guidance from the Department of Labor still requires that a worker's separation be involuntary to qualify for unemployment benefits, including PUA. So common reasons for disqualification include severance and vacation pay. We talked about that. If you're receiving benefits from your employer, you're not going to be eligible for those weeks that you receive the benefits. Again, we also talked about being able and available. So we're now going to direct our discussion to suitable work, voluntarily quitting without good cause, misconduct, and misrepresentation. All right, we have a PUA question before we get to suitable work, David.
Okay.
So the question is, the job ended due to COVID, and the person applied for regular benefits. The case is still pending resolution, and they want to know whether or not they should apply for PUA while they're still on furlough. Again, if you're eligible for regular state unemployment benefits, you have to apply and go through that process first. If there's a question about that eligibility, based on the parameters we discussed in terms of PUA, then yes, if you believe that your application for regular benefits is going to be denied because you are not eligible for unemployment benefits, I would say go ahead and apply for PUA. But if you're eligible for benefits, you have to go through that process first.
Right. No, but you are kind of exploiting the problem that they have, two separate application systems. Why not? If they're not giving you any money, Governor Sisolak promised PUA would be available this Saturday. So I would say go for it. It's certainly not any problem because you as a claimant don't really know whether you qualify. And if you're not getting the benefits, what's the conclusion? You don't qualify.
That is true. Yeah. I mean, it's certainly not going to hurt you. I don't think applying is going to make you ineligible. They're going to tell you what you're eligible for, essentially. Well, that's
Right.
my understanding of how the PUA system is supposed to work. If they believe you're eligible for regular benefits, they're going to tell you to apply under the regular system. Okay, so the first disqualification reason we're going to discuss is suitable work. So this is assuming you've applied and your claim has initially been approved. These are suitable work is an ongoing sort of issue in terms of that able and available requirement, right? You have to, under normal circumstances, apply for work and submit work search records. So what jobs, though, are you applying for, and what offers are you required to accept? So you have to apply for available suitable work and accept an offer of suitable work. So refusing suitable work is a cause for disqualification. Whether work is suitable depends on the degree of risk involved to your health, safety, and morals, physical fitness and prior training, experience and prior earnings. Again, these are things that, your customary occupation, but it's not just limited to your customary occupation. Because the longer you're unemployed, the more you're going to be required to look outside your prospects in your customary occupation and accept things that are not necessarily 100% wage replacement. You cannot simply say, if it's not 100% wage replacement, it's not suitable work. That is not the definition. Suitable work is not the same employment. It's just similar wages, terms, and conditions. Not the same, but similar, and the actual language that's used is substantially less favorable. So suitable work is a job where the wages, terms, and conditions of employment are not substantially less favorable than those for similar employment. What does that mean? We don't know, essentially. I mean, there is an indication that suitable work is 80% wage replacement, But I would argue that, I mean, I would be careful in the sense that I think they would argue the length of unemployment is going to inform what's suitable and what's not.
But you can also see how this is totally favoring a deflation and decreasing of wages, because if you fire a worker and they have to accept a lower paying job, it just puts more pressure on salaries and income if employers can do this.
Right.
That's a larger issue, but I mean, it's related to unemployment benefits and how it is really pro-employer.
Right. Okay, so going back to the main reasons that you can be denied based on your prior employment. So we're going to start with good cause to quit. You cannot voluntarily leave employment and become eligible for unemployment benefits unless you've had good cause to quit. Good cause is not really defined. It's generally sort of defined by ESD as a compelling reason to quit and that you have no other reasonable alternatives but to quit. Leaving a job which is not suitable can be good cause. We just talked about the suitable work requirement, but this talks about leaving a job, not applying and accepting suitable work. But essentially, we're looking at wages are not less than 80%, but this requires that you're going into an approved training program. So it's not a blanket, you can leave a job that's not suitable if they reduce your wages. You have to then go into approved training in order to be eligible under this section, but it does sort of inform the suitability argument and in terms of when you have good cause to quit. But remember, you can receive partial unemployment benefits. So if your wages have been reduced, if your hours have been reduced, then you can continue to work and apply for benefits and potentially get benefits based on that part-time employment. But it does require that you attempt to resolve the problem with your employer. So you have to make reasonable attempts to keep your job essentially. You have to go up the chain of command. You have to address whatever is at issue with the employment or working conditions. You know, going to HR, complaining to a supervisor, putting all of this in writing because the burden is on you to offer the basis that constitutes good cause, that you had a compelling reason to quit and tried to work things out with your employer before you applied for unemployment benefits.
I mean, like the scenario basically pre-COVID was you're having a dispute with a particular worker, so you want a different schedule. You have childcare problems, and you want to come in a half hour later and work a half hour in the afternoon. These are some of the things that people will point to when they quit, and what exactly does constitute good cause. Well, in these situations, it does require you to work with your manager or your boss and to try to get a flexible schedule and to document those efforts and to prove to the Employment Security Division that you did try to work this out and you just didn't go straight to the quit option.
So in terms of the COVID-19 era, a big question we've been getting is, and we kind of addressed this or hinted at it earlier, can you quit if you're afraid of getting coronavirus? Probably not. Again, I think, using the scheme for good cause, compelling reason, reasonable alternatives, it's going to depend on your individual circumstances and what is going on with the employment. We've also received a lot of complaints from employers not following the OSHA guidance on social distancing and PPE. If that's the case, I mean, OSHA is taking complaints and investigating complaints. I doubt that they're investigating every single complaint that comes in. I believe it's in the thousands, which obviously shows a lack of employers willing to abide by social distancing and PPE requirements. But essentially, you have to document, what steps you've taken to try to address the failures of the employer to abide by regulations, and it's got to be compelling. So I don't know, if you're not old, you don't have any health factors, you're probably not going to be eligible for benefits if you quit in fear of getting coronavirus. Maybe it changes if you do have a compromised immune system. Again, I
Right.
think it's going to depend on everybody's individual circumstances.
I mean, but the aspect here is it's involuntary, so it's a little bit
Right.
more than compelling. It's involuntary. And, we talk about germaphobes like Howard Hughes or Howie Mandel, or, people who do have disabilities based on the intense fear of getting sick or getting COVID. Generally speaking, um, they would have a reason, just a generalized fear and the mental disability of this illness that's surrounding us. It hangs in the air for long periods of time. I don't want to get too dark, but some people with mental disabilities, this COVID crisis hits them at a very sort of delicate spot. So, I would think that's involuntary, and I would think they would have good cause for quitting.
It's convincing ESD and all the guidance we've received
Exactly
that it's
right.
really
Not
restricted.
everyone is a germaphobe like Howie Mandel.
Right. But I do think that, people with significant health factors, there is an argument
Exactly.
to be made.
Right. We have enough people in our society with diabetes, and diabetes is one of the risk factors. It's involuntary, and it could, if your employer is not taking any efforts to protect you, then that probably is good cause to quit.
You still have to try to, document your efforts to force them to comply, though. That I would say is still a requirement. So
Sure.
definitely you need to be taking steps and calling OSHA, getting other employees that are similarly situated or, potentially
Let's not go too far.
yeah.
So we
But
know
no, I
that.
mean, in terms of, making sure that you're not
Oh,
acting unreasonably.
right.
That
Calling them and having OSHA do something are two separate things. We know that OSHA won't do anything if the employer shows good faith in trying to comply with these COVID protocols. And the aspect of calling and documenting that, or emailing, is even better because you can print that out. That is useful if you're going to show good cause for leaving.
right. Other laws are still in effect. We've talked about OSHA. And if you are disabled, you could still request a reasonable accommodation based on your disability that could impact your employer outside of, this good cause to quit scheme, and potentially force them to allow you to do things like telework or have a flexible work schedule, something that would require them to take actions to accommodate your disability. And then, as far as whether or not your workplace is in imminent danger under OSHA regulations, you do have to show that such a danger exists, which could reasonably be expected to cause death or serious physical harm before such danger can be eliminated through the enforcement procedures of OSHA. So again, as David was saying, if the employer is taking steps, you have to show that what they're doing isn't going to protect your life, essentially. That's a very hard standard to meet.
What I'd also encourage people to look at is Governor Sisolak's protocols, which have so much detail, like 50% capacity in restaurants, grocery stores, things like that. So when I go to a grocery store, my local one, I don't see them with a counter counting people. And if you're working there and it's crowded all the time, that could be a basis, or one of the factors for quitting, is if there's more than 50% capacity.
Right. Again, can't stress enough, individual circumstances, each employer is going to be reacting differently, but you still need to take the steps to address the issue before quitting.
Exactly.
All right. If there are any questions about good cause, we will come back to this issue. I know it's probably the biggest one that we get questions about, but we'll go ahead and move on to another reason you can be disqualified when you apply, which is if you were terminated from previous employment because of misconduct connected with your work. Misconduct has been defined in case law. It is sort of a convoluted definition. There's essentially three parts. So you have to have a deliberate violation or disregard of standards of behavior which your employer has the right to expect, or carelessness or negligence of such a degree to show a substantial disregard of the employer's interests or your duties and obligations to the employer, and ordinary negligence in isolated instances or good faith errors in judgment or discretion are not misconduct. The employer has the initial burden of of showing you committed misconduct, but you then can, after that, essentially justify your circumstances by showing that you did not engage in disqualifying misconduct because your actions were reasonable and justified under the circumstances and were not wrongful.
And one thing to emphasize here, and every employee who is terminated for misconduct, there's a whole story behind it. You have to understand that when you go to a hearing, when you deal with this issue with the Employment Security Division, they only have a tenth of it or even less of what's going on and the history behind, your relationship with other workers or the boss or whatever. So, you may be feeling like you were wronged or you have, a perfect reason for doing what you did. You should try to forget about that and concentrate on the information that the referee has or the adjudicator has, because that's going to be the record, that's going to be the history that the Employment Security Division looks at, not, the 20 years you worked for the company, but the last 10 minutes, let's say.
And again, as far as misconduct, we're not saying that every violation of a rule or policy is misconduct. Employers will often say that, but it really does have to be, an important, you did something really wrong, not,
And typically it's when your mistake causes monetary harm for the employer.
right, exactly. And that's really, unfortunately,
Right.
one of the things that the employers often highlight is if you cause monetary harm, then you're going to have a really big hill to climb. All right. Finally, in terms of disqualification, we want to talk about misrepresentation because you do not want to lie when applying for benefits. If you make a false statement, knowing it to be false, or knowingly fail to disclose a material fact in order to obtain or increase your benefit, you will be disqualified for benefits. Now, remember, when you apply for unemployment benefits, ESD turns around and reaches out to your employer, and they have a chance to submit a statement. Then ESD is going to call you and investigate your claim, unless the employer's information matches yours. So it's really important that you not lie when you apply for benefits. If you were not laid off, do not put that you were laid off, even if your employer says, I will not contest your unemployment benefit claim. We hear this all of the time. It doesn't matter. If your employer believes you're lying, they might decide, well, we didn't do that. We're going to say that what really happened. So make sure you do not lie because you could be disqualified for up to a year from getting unemployment benefits in the future. And you'll obviously have to pay back any benefits you received.
But also realize you don't commit fraud if you just click on a wrong box
Right.
or miss some drop down or whatever. And when you go to the application, online application, there's these fraud warnings all over. We're not going to say disregard them, but fraud is usually when you intend to deceive, not when you make a mistake.
Right. It has to be knowing. You have to be making a knowing false statement. So just making a mistake is not misrepresentation that we're talking about. All right. So the claims process, we have kind of addressed this, but this is not, this is, you file a claim, you give your reason why you're separated. Again, we just talked about this. This is an issue for misrepresentation. You then you'll set up a phone call. I know that the phone has been an issue, recently, but essentially, eventually you should get an interview with the claims adjudicator. If there's any issues with your application, you will be able to talk to somebody to try to figure things out. Hopefully the call centers are getting it and processing the claims. But be aware that when you have that interview, the adjudicator will put them in writing and it does become part of your claims file. So those notes will, potentially could be an issue at a hearing. The decision that is issued by the claims adjudicator after the interview, which you can appeal within 11 days. The appeal must be in writing and signed, include your social security number. And then once you appeal, you'll get a hearing scheduled before an appeals referee. And then, depending on the jurisdiction and in this day and age, I think the hearing is going to take a while to get scheduled. but you would be essentially able to have a hearing before an appeals referee.
And Ray, can you go back for a second?
Yeah.
That first or the second point is really a good one, because a lot of people, they don't want to say they quit. They want to be proud or whatever. If your hours were reduced, if you had your boss suspended you, whatever, you should describe the correct circumstances upon leaving. And if you just are embarrassed by the word quit, don't be embarrassed, because that could be like, if you say you were laid off when you actually quit, that could be a reason for ESD to charge you with fraud.
Right. And so just to clarify, you're not necessarily going to get a phone call from a claims adjudicator if all of the information that's submitted supports the claim. They might have to call you if there's a mistake in the application, but I think it just depends on what ends up happening with your claim. I don't necessarily believe every claim is going to require a phone interview. It just depends on, if you make a mistake, if the employer submits information that contradicts what you said, or for PUA, if there's an issue with substantiating your wages, or you clicked a button wrong, there might be a reason for an interview, but that doesn't mean that every single application is going to have an interview. It just depends on what information is submitted and what information the Employment Security Division needs to double check. Now, if something comes up during your claim, even after you've filed and received benefits, there could be intervening reasons why your claim might have problems in the future, and they could call to interview you at any time.
One final point is, when you get your hearing with the referee, it's going to be by phone. They're probably going to send you a notice 48 hours before the hearing to confirm your telephone number. Respond to that. It's very important. Even though you've given your phone number probably 2 or 3 times, you have to do it again, because if you miss that hearing, you're going to lose.
And David, we have a question about getting through on the phone lines and whether sending an email is going to work. It's my understanding that there is no way to email regarding applications at the moment. I believe there is an email address set up if you have problems like accessing the online systems, but I am not aware of any email for actually submitting and or addressing issues with the claim. That is still required to be done by phone.
Right, right. No, that's probably fraud or phishing or whatever. The application is online or by phone. And when you get notice of the hearing, that's by email, but only because you gave your email in the application. So yeah, there shouldn't be any exchange of information by email as far as I know.
Yeah, I'm not aware that they've allowed that at this point. I mean, I think they're still requiring fax documents as well.
There's warnings all over the application website, avoid employment security fraud. We will not contact you, and things like that. So
Yeah.
maybe some fraudulent party trying to get information.
All right. So once you request the hearing, an appeals referee presides over the initial evidentiary hearing, and this is your only evidentiary hearing. It is the only time you will have the ability to submit evidence. Okay. So we just talked about not emailing. You, I believe, are still required to fax documents to ESD for the hearing. I don't even think the online system has the opportunity for people to like upload documents, which would be the next I don't know why you can't upload things, but essentially you have to make sure that you get all of your evidence submitted before the hearing, and have witnesses. If you want to call witnesses, you need to have them available for that hearing. You can't say, oh, well, my witness wasn't available, and try to get that in on appeal. Once you have your hearing, it's basically over at that point. The only grounds you would have to contest it is through the appeals process. You will, though, in your online system, be able to access the hearing packet before the hearing. So do check your portal before the hearing, and then review that file so you can supplement it if you notice anything that's missing, or you have documents that your employer has not provided. But you do testify under oath. The appeals referee will swear all of the witnesses in. Once you have that hearing, again, I can't stress enough, It is the only opportunity you have to submit evidence. But if you lose, you can appeal the hearing to the Board of Review. The Board of Review is just a 3-member panel. There's a representative for labor, a representative for the public, and a representative for the division. Now, that 3-member panel is not necessarily required to have a hearing, so just be aware of that. They're only required to hear the cases if the referee overturned the original determination. If the decisions were the same both times, the Board of Review is likely just to deny review. So to get the hearing before the Board of Review, again, you have to file the appeal within 11 days. The appeal has to be in writing, has to be signed, has to include your social security number. And this time you do have to provide reasons for the appeal because again, the Board of Review does not necessarily have to have a hearing. So if you have a good reason for your appeal, you want to lay that out at the time you appeal the decision. And then if you lose again at the Board of Review, which honestly is going to be really likely, you'll have 22 days from the Board of Review decision to file a petition for judicial review in district court that has jurisdiction over your place of employment. So you do have the ability to get in front of a judge in district court if you've lost your hearings prior to that point. And that does require you to file a petition. It's called a petition for judicial review, but you file that in court. And then you have to serve ESD.
You can't emphasize it enough. Some people think that they've got great cases. They go to the hearing, they go to the Board of Review, and they may even file their petition in district court, and then they come to our office. That's way too late in the process. If you are denied unemployment and before your hearing, you should contact us because you do have months potentially between when you request a hearing and you get your hearing. So we at Nevada Legal Services can investigate, get the file, look at whether there's things that you can do to qualify for unemployment benefits. And certainly you can go on your own if you want, and you can just take our advice, but we can represent you during this process.
And at the end, we will have contact information for our offices, but you can also get that information on our website. It's nlslaw.net, which you can also link through to from our YouTube page. But that does it. Here is the contact information for the offices. Please feel free to give us a call. As David said, we do represent claimants who are denied unemployment benefits, and we can possibly help you at the hearing. So give us a call and we can determine if you are eligible for our services. But again, if you have any questions or anything that you would like us to address, please go ahead and include that in the chat below. We'll stay online for just a little bit longer to field any remaining questions. But just, I understand that there's a lot going on right now with the economy opening up and people being afraid to go back to work. We understand, but as David mentioned, things are pretty strictly construed against employees right now. So just be aware of that.
I'll also mention, which really isn't a matter of broad public knowledge, when you do apply for unemployment benefits, the Employment Security Division will also be matching that information with the Department of Welfare to see if you're eligible for any other benefits that could help you during this COVID crisis.
And I do believe we have one other question, so we'll stay on to see if there are any additional questions just for another few minutes. But I do definitely, if you're denied, you want to make sure you keep track of your online portal for sure. And anything that looks like you're ineligible, give us a call. If it's just taking a long time to process the application, I have to be honest, I don't know that there's too much we can do about that. But if you have a determination of ineligibility or you're officially denied, please feel free to give us a call.
Yes, we've talked to so many people who just say it's just nice to talk to a human being. It's like, have you seen me? No, it's a frustrating and long process. So you need a lot of patience to get through it.
Yeah. So we do have one final question, David, and I unfortunately don't know the answer to this. I assume it's something to do with misconduct, but I know we had a discussion about the PPP program. But the question is, the PUA claim asks if you've been convicted of a crime. There's an option to answer, prefer not to answer. But why do they ask whether or not, um,
If you engaged in criminal activity at work, you're not eligible. So I think that's the reason they're asking.
and that's what I thought. Criminal activity is a separate category from misconduct. I apologize. I tend to loop it in with misconduct, but there is a criminal activity
Yeah. If you
disqualification
kill a
that
customer, yeah, it's
yeah.
misconduct. I mean, sorry, I don't want to be flippant, but
Yeah. No, I do apologize. That is something that we don't generally address. And I guess I forget about it sometimes. But yes, if you commit a crime in your previous employment, you are ineligible for benefits.
it's so, it's so easy. Like if you do injure or harm a customer that, I don't think I've ever seen one of those cases. So we don't talk about it, but yes, if you committed a crime at work, that's misconduct.
And I don't want to make assumptions, honestly, but I assume if you choose the prefer not to answer option, you might have to get a call and talk to a claims adjudicator at that point. They might follow up with that question.
Right, right. Because that's
Um,
the natural question. Was it at work or was it somewhere else? And
right.
you could get into that Murphy sort of Evans analysis too, whether you were not available for work because you were being held.
Incarcerated, right. And then we have another question. Somebody appealed a determination that they were ineligible when applying for regular benefits, but they're an independent writer and a regular gig was postponed. I would apply for PUA.
Exactly. Yes.
So I would not, I mean, I think you're fine appealing the other determination, but I would go ahead and apply for PUA. I know that claims are getting processed right now, and that does seem to me to be a situation where PUA would be more appropriate, I guess is the answer for you to apply for PUA. And then if you're approved for PUA, then you can abandon your other claim.
Exactly.
And again, I understand, like, we were concerned initially, or at least I was. I don't know how you felt, David, but when they had the original system and they kept saying, wait, PUA, wait for us to come up with this system for accepting PUA applications. And people had applied through the original process. And they're getting denied. There's ineligibility determinations, and I was worried about telling people to appeal because I feel like having two avenues would be a problem. But at this point in time, based on what I understand of the PUA system, apply for PUA. Do not worry that you have a separate application process because it is ESD's requirement to tell you what you qualify for, essentially. So
Exactly.
go ahead and apply for both. I would not worry about that at this point.
I would call them two bites at the apple, and you should take it if you have the ability, and this writer has the ability to do that.
I agree. I think at this point, just, apply for whatever benefits, and it should be their requirement to tell you what you apply for, what you qualify for, excuse me. Okay, but that looks like those are all of the questions for now. Again, like I said, if you feel more comfortable giving one of our offices a call, please do so. We'd be more than happy to at least give you advice and essentially make a determination whether or not we can assist you further. But thank you so much for attending. We really appreciate it. And if there's anything that we can do to help you out in the future, please let us know. But thank you for joining us, David.
Thank you.
And that will do it for our unemployment benefit live presentation today. Thank you so much, everyone. Have a good rest of your day and week, and good luck with applying for PUA.
Yeah, sardonic laugh right at the end.